now. We're going to talk about the HIPAA audits and the OCR changes that are occurring right now. We're also going to talk about HIPAA-based litigation in state courts and what that might mean for your business, as well as privacy and security concerns, regulatory inreach with the introduction of a new regulator who's looking to play in the healthcare arena. They're certainly not a new regulator, but they're new to healthcare and they want to flex their muscles, and they're trying to do so already. And then lastly, we're going to cover some tips for medical courier compliance programs, what you can do to start building a compliance program if you haven't already started. And then again, we'll open up for an open mic session to answer any and all of your questions that you might have. So with that said, let's start talking about the business associate agreement. Back September 2013 was a compliance date for the omnibus rule, and that's when business associates were now fully liable and expected to fully comply with HIPAA's privacy and security rules. Heavy emphasis being on the security rule compliance, which in turn has had the implication of rather significant IT controls to be put in place within the organization. And then there's also compliance with specific state privacy laws, and the reason for that being that as you operate in your state, it's the state laws, privacy laws, that give plaintiffs a day in court, and certainly that private cause of action. HIPAA itself does not provide a private cause of action. So if there is a patient whose data has been breached or improperly used or disclosed, they can't sue you, they can't sue a covered entity for that breach in federal court under HIPAA. There's simply no course for them to do so. So they sue under state privacy laws. And what we have seen here is that the business associate agreements are getting more sophisticated. 2-3 years ago, as we were talking about business associates and the need for those agreements, it really was a 70-30 slant. 70% of the time it was the business associate who was going to the medical provider, to the lab, and saying, here's the business associate agreement that needs to be executed, because most covered entities simply weren't preparing them. They knew very little about them. They didn't spend a lot of time on it. So the business associate was handing them an agreement. They would sign it. The associate would countersign it with very little fanfare, very little review of that. Fast forward 2 years now, or a year and a half into the compliance of the omnibus rule, and what we have seen is that covered entities, labs included, are getting much wiser about those business agreements. And they are putting in far more stringent compliance requirements, again, specifically around that HIPAA security rule. They're also drawing out compliance requirements for the covered entity and its downstream subcontractors to comply with the specific privacy laws in the state that governs that business associate agreement. And we're also seeing where they're defining security incidents that do and do not require per incident notifications. Sometimes they'll batch them. Other times they want to know every time there is a particular incident. So we're seeing that spelled out with great specificity of late. We're also seeing a trend where the covered entity is increasing the indemnification and reimbursement frameworks for business associates. So one thing you definitely want to be sure to look at if you are handed a business associate agreement, or on a renewal, the covered entity is handing you a business associate agreement. You're going to want to review that. You're going to want to review that with your attorney to make sure that there are not overly broad indemnification and reimbursement frameworks built into that contract. State law will obviously govern it, and those laws do vary by state. So that's why, again, it's important to review those agreements with your attorney to make sure that the covered entity isn't being too overly broad, and more importantly, that you're able to meet those indemnification and reimbursement requirements. Should there be a breach, they're spelling out what you're going to pay for on their behalf. Because keep in mind, they are responsible for any breach that may occur at your level or even at your subcontractor level. And what they're trying to do right now is to indemnify themselves and push all of that burden down to you. And we had expected there was going to be some liability shift, but I am quite surprised at just how extensive that liability shifting is occurring right now in these agreements. And understand that the business associate agreement is going to become the basis for this business-to-own relationship between the courier and his client. It is going to take on far more emphasis, particularly later this year and into 2016 and 17, when we see the Office of Civil Rights within Health and Human Services start up their phase 2 of their HIPAA audit program. This is one area that they are going to look at. They've already told us that, and they have told us that business associates will be included in those round in the phase 2 audits. So we know that they're going to be looking to see those agreements. Talking about HIPAA audits, let's segue into that real quickly. As some of you may be aware, Health and Human Services, specifically the Office of Civil Rights, had several years ago started its rather aggressive HIPAA audit program. At the time, it was focusing almost exclusively on covered entities, with a few exceptions outside of the traditional covered entity. And they had contracted with the firm of KPMG to do a lot of the groundwork for them on that. And it was a pilot phase. Well, that pilot phase is now completed. They wrapped up in 2014, and they're going to now be revamping from the lessons learned and rolling out in 2016 the phase 2 program. So good news is we're going to see a fall off in HIPAA audits this year. However, complaint-driven audits and examinations will still occur. So if they receive complaints, they may still very well be coming out. If they feel that the complaint, or if they have a pattern of complaints against either a covered entity or a business associate is received, then they're going to obviously come out and do an audit. But in terms of just the random, hey, you won the lottery and we picked your name, so we're coming out to see you kind of audits won't resume again until next year. What we learned from the pilot program and the pilot phase was these audits were absolutely intrusive. Audits at the federal level are structured according to the Administrative Procedures Act, which basically sets the framework for all federal regulators in terms of how they go about their rulemaking process as well as their audit and examination process. And typically it follows a very similar flow with any federal regulator. And those audits start with a notice of audit. And those can be issued anywhere from 90 to 180 days prior to the audit. And you're usually going to get a production request, either with that notice or shortly thereafter that notice. These notices can be fairly long. On average, they're between 60 and 80 pages long. And they're going to ask for all kinds of documents that need to be produced. They're also going to, in that document, tell you how to produce or how to provide them, the auditors, with those documents. And they'll spell out the electronic file types that they will accept, and they'll usually give you a secure port where you're going to be uploading all of those. You're not going to be copying and mailing them. After that, you're going to have a kickoff call with your lead auditor anywhere from 30 to 60 days before the audit, and then they'll, at that point, also provide you with what's called the in-hand delivery request. And that's basically a smaller, usually smaller document of items that they want you to have ready on day 1 of the audit. And when they show up, you should have these ready. You turn those documents over to them, and then that's how they get started on their audit. Because when they got your initial production, they already started testing off of that and reviewing that. So now they're asking for some follow-up documentation. And they'll be on site, and they'll be on site for anywhere from a week to a couple of weeks. It could be 2, 3, 5, 8 auditors. It varies, and usually by the scope of the business that they're auditing and the time frame with which they have to conduct their audit. So that's a typical framework. What we saw with the initial HIPAA audits was that KPMG was not subject to the Administrative Procedures Act, obviously did not structure their audits that way. A lot of entities were told, we're going to be coming out, we're going to be auditing you, and then it wasn't until the first day when they walk in on Monday morning, and now they're handing an 80-page document saying we need this by Friday. Well, you can imagine the impact to a small business, whether that's a doctor's office or to a business associate who may have been targeted in the pilot phase. And imagine the impact on a business when you have to drop everything you're doing just to comply with producing these documents in time. So it was very taunting. It was very labor-intensive and frankly, just absolutely intrusive. What we have heard from OCR is that the new program, Phase 2, will be a much less intrusive audit. There will still be production requirements, but you're going to have that lead time. And they are going to be following the Administrative Procedures Act with this because they're doing it. They're not going to be using KPMG or another third party again for the sheer fact that those guys aren't required to follow the APA, and as such, that added to the complexity and the burdensomeness of the initial audits. They have indicated that business associates are going to be subject in Phase 2 I don't know yet. We haven't heard the percentage split. Is it 50-50? Is it 75-25 between medical practices and business associates? So we don't have that kind of clarity yet, but we do know that business associates will start being audited at random beginning in 2016. There's going to be a heavy emphasis in the audits in Phase 2 on both privacy and security rules for the business associates. They're going to be looking not only for the business associate agreement to be in place, but they're going to be making sure that the business associate has a compliance program or plan in place. They have the required HIPAA policies and procedures. There are 55 of them that have to be implemented. You're going to want to make sure that you have those written policies and procedures and that they have been implemented in your practice. They're not just sitting in a binder collecting dust, but that they're actually being practiced on a daily basis. And so I think we certainly have the framework for what they're going to be looking for. And I'm not sure how you want to read this next part. I'm still kind of shaking my head on it because the new director for OCR who took over late last year stated that enforcement actions are not a primary focus of the audit program. We're here to ensure that the business associate or the covered entity is working to achieve compliance with all requirements, and we want to provide guidance where they're falling short. However, if we see something that necessitates an enforcement action, which could be a fine, it could be a corporate integrity agreement, it could be a referral to the Department of Justice, we'll still go ahead and take those, even though it's not a primary focus. So I don't really know that anything much has changed on that because that was the same stance that took in Phase 1, but I guess they want you to feel more comfortable in saying the first objective of their auditors is not to find you and got you, we've got an enforcement action. But if they see something that's worth it, they'll take it. And the best guidance that I could give you on that is to be prepared, one, for the audit, and certainly work with the auditors when they're on site. Don't try to be obstructive. I know it's a knee-jerk reaction to be suspicious of them and to question whether or not you have to comply with what they're asking for. But try to work with them at least within reason, because the more cooperative you are, the more likely they are to provide you guidance as opposed to wanting to fine you or take some other form of an enforcement action. And as I had indicated earlier, there have been some leadership changes in OCR. Not only do we have a new director as of late 2014, but we had several senior staff assistant directors either retire or moved into new positions, either within OCR or Health and Human Resources. We had one exiting, go to the EPA, and we had one go to the U.S. Department of Transportation. So they got out of healthcare completely and went elsewhere. What does that mean for us? We're not really sure yet. This new leadership team hasn't been in place long enough just yet for us to get a read on what kind of shift we're going to see in OCR's posture towards business associates such as medical couriers and their take on HIPAA compliance. So far, there's an indication that there's not going to be any radical shift. It looks like it's business as usual. But for those of us who follow this, we're going to be paying very close attention to their initial or early enforcement actions taken here in the first quarter and a half of 2015 to kind of give us a litmus or a guide as to where they may be going. We're also going to be looking at guidance and educational materials that they put out in the first half of this year to kind of read and get a sense on it. Are they keeping a status quo? Are they trying to flex their muscles and make their own mark as a new leadership team, or are they going to take a different stance? So there may be some guidance that I'll be providing to Ken to put out to the medical courier connection as the year goes on. Is if we start seeing some indications with OCR and specifically any commentary they put out about medical couriers, we'll obviously want to get that information out to you as soon as we can, just so that you can plan for it. The other and slightly more disturbing trend that we're going to have to watch in 2015 is that we expect more HIPAA-based suits to be filed. Now, if you remember what I said a few minutes ago, that there is no private cause of action, you're probably sitting here now going, well, if you can't sue based on HIPAA, then what the heck's going on, and what are these HIPAA suits? Well, there were two key cases in 2014 at the state level that were decided at the appellate level, both of which allowed HIPAA to be used as a new standard of care, reasonable standard of care, or standard operating practices around the protection and use of PHI. Before that, it really was up to state law to define what was a breach, and most of those state laws did not cover the depth and the specificity with which HIPAA predominantly a security rule goes into. In both of these cases, what has now happened is state appellate court level justices have recognized that, you know what, HIPAA is the standard of care when it comes to medical breaches, either by a business associate or by a covered entity. And as a result, if it's now shown that, hey, you know, this business associate should have complied with all the elements of the security rule and they didn't, and that failure to comply led to the breach that caused injury to me, then now I have a cause of action, and I can prevail in court, in state court, against either this covered entity or this business associate. Those two, the first of the two cases was Byrne v. Avery Center for Obstetrics and Gynecology. This is a Connecticut case, and it was ruled on in late 2014 by the Connecticut Supreme Court. In Byrne was a patient of the obstetrics division of the practice. She was pregnant. During the course of her treatment prior to the birth of her child, she ceased relations with an individual who was a potential father for this child. After the breakup between the two parties, the potential father filed a paternity action in court to find out if he was the father, and he subpoenaed her medical records. When the practice received the subpoena, they, one, did not notify Byrne that they had received a subpoena for her medical records, nor did they go to court to contest it. They didn't even show up at the evidence hearing. They simply turned over the records right away, gave it to the court, and at the evidence hearing, the court handed it to the other party to the relationship. He got those medical records, and then he started harassing Byrne. She then summarily filed suit against Avery for negligent disclosure of her medical records, violation of HIPAA, and for the negligent infliction of emotional distress because of the stalking and the harassment that she was receiving from her former partner. The Supreme Court ruled on two key issues, and the first one was, does HIPAA prevent a state cause of action? And they said, no, it does not. You certainly can bring a state action against that medical practice. And more importantly, the second issue they ruled on is that HIPAA can be used as a standard of care. And in this case, this was not so much a security rule as a privacy rule issue, where the medical practice did not follow the requirements of HIPAA. HIPAA spells out what a business associate or a covered entity is to do when they receive a subpoena. Since Avery did not follow the requirements of HIPAA for subpoenaed medical records, it was determined that they had in fact breached HIPAA. They breached that standard, and as such, the case could proceed forward under state privacy laws. And again, that was the highest court in the state, so that case is all well and done unless it's appealed at the federal level. We don't think it will be. But it's certainly concerning because it clearly created or set the threshold for HIPAA to now become the standard of care that needs to be exercised when it comes to a state case. In the second case, which is Walgreen Cove v. Hinchy, Hinchy is a patient who had prescriptions filled at Walgreens, and an individual pharmacist at an individual store misused Hinchy's medical records. In fact, they took those records and sold them to somebody who wanted to market other things, and so they had entered into a profitable relationship with this marketing firm, and they clearly took records they should not have been taking. So it was a clear breach of HIPAA. And in that case, the Indiana appellate court was asked whether or not the $1.4 million verdict could stand because HIPAA doesn't, HIPAA is a federal rule, not a state rule. How can you argue HIPAA? Fairly similar to what Avery was arguing in Byrne, that, hey, HIPAA has no place here. That's a federal rule, and at most we're only subject to enforcement actions from the federal government, not to state court litigation. And the Indiana Supreme Court said, no, we do think that HIPAA applies, and as such, we're going to uphold that $1.4 million verdict. Now, that decision is on appeal to the Indiana Supreme Court. We don't know if Indiana Supreme Court is going to issue a writ of certiorari to hear the case or not. If they do, it'll be interesting to see how they rule on it. But all indications are right now there's probably no appetite. And, the Indiana court is well aware of Connecticut's ruling. They may choose to uphold and not even hear arguments in this case, in which case then, there'll be a second Supreme Court going on the record that HIPAA does set a standard of care that needs to be followed. So this certainly is an indicator of things to come, and it is certainly something that those of us on the legal and the compliance side certainly get nervous about, because now it may mean there's a new litigation front opening as if we needed another one. We're already a rather litigious society. Let's not go give the trial lawyers any more opportunity to come after us than we need to. So beware, there's more to come. We're going to be watching in 2015 to see what this does to case filings and see if we get any other appellate level rulings in various states to see what this trend is going. We are probably still realistically 5 years or more away from any federal court rulings, just given the time frames and the pace with which our judicial system works. So I don't expect that we're going to see any federal court weighing in on this anytime soon. But I do think that we're going to see this play out in more state courts over the next couple of years, and certainly 2015 being one of those years. So with all of that said, there are a couple of things we want to keep in mind. First off, is increased emphasis for the Office of Inspector General on VA compliance with HIPAA security and privacy rules. That's been articulated in their work plan this year. We know that OCR is going to be looking at those when they come up with their audit protocols for 2016. The Anthem Healthcare, Home Depot, Target, and Chick-fil-A incidences of the last 12 months, 12 to 18 months actually, all increased pressure for compliance, and particularly on data security. So if anything, I would say this is certainly the time to be taking a look at, do you get PHI? How do you get that PHI? How are you handling that PHI? Are you storing it? If you are a courier company that has direct interaction with end patients and consumers, maybe you deliver home medications, home therapies, and you have more extensive PHI records and that you maintain on a regular basis, you definitely want to be taking a look at your data security concerns around that, because that's going to be a big one in the early audits. And I would say the greatest risk to couriers comes from disgruntled employees and subcontractors. For every one of the big breaches like an Anthem Healthcare or Home Depot, where we have hackers who go in and do it, there are a tenfold number of much smaller cases. We had one recently here in Orlando with a compounding pharmacy where, a disgruntled employee decided he was going to go out and just drop off medical records in public places to be found, and went to some of our libraries and did it. We had another compounding pharmacy where a manager wasn't getting the promotion or the pay increase that she wanted, so she ended up just, instead of being bothered to properly dispose of medical records, she threw them in a dumpster where they were found. So again, for small businesses, you're right to say that you probably fall under the radar of hacking organizations and large-scale criminal rings that want to gain personal data and PHI to sell on the black market or for identity theft purposes. You're absolutely right that you probably fall under the radar and they don't know about you. But the problem will come from your employees, and I can assure you, looking at the records and doing audits and being a federally certified independent compliance monitor for corporate integrity agreements, I can tell you that for everyone where we've got a criminal mastermind who ends up stealing stuff, I can take a look at just employee error and disgruntled employees who actively and consciously and willfully go out and violate the law to get back at their employer. So that's where the greatest risk is going to be, and that's why, again, it gives us pause to take a look at what controls do we have in place for when we do either terminate an employee or we've got an employee who's getting disgruntled with us. What protocols we have in place, what safeguards we have in place so that they cannot go ahead and create a HIPAA breach and a violation for us. And again, keep in mind that you may be exposed to civil suits in state courts. We've seen this right now. It's Walgreens, and it's a medical practice. It's only an amount of time before it comes down to business associates. Do I think couriers are going to be the first in the set of litigation for business associates? Probably not. I think we're going to see others. But again, we don't know where that can boil out, and it only takes one incident and one disgruntled person to haul you into court. So it is something to be cognizant of, if nothing else, in 2015. This next slide I want to just briefly go over, and again, we'll make these slides available to you, so I'm not going to read them in full detail for you. But the three big areas that you want to make sure that you're addressing are privacy, security, and what happens in the event of a breach notification. And all three of these are going to end up making or forming the framework for your business associate agreements. You may or may not have a notice to privacy practices requirement. Again, if you directly work with patients and you have their personal information, then you may very well have a notice to privacy practices requirement where you have to have a privacy policy and provide that to them on an annual basis. For most couriers that I work with, this is not such a deal, but again, I do have some couriers that I consult with who that is an issue, and we have to do that for them on an annual basis. You have to understand about the rights to request privacy protection for PHI that the patient may have. Access of individuals to PHI, who in your organization has access to that data, and is it reasonable and necessary? If it's not absolutely necessary that somebody has access, then they should not have access, and you should be taking all reasonable measures to ensure that they don't have access to PHI. The administrative requirements set forth in the privacy rule all apply to business associates across the board, so you want to make sure that all of those are in place. And some of those include having the appropriate policies and procedures in place. Uses and disclosures of PHI, you want to make sure that you're tracking those. If you in any way alter or amend PHI, you need to understand those situations when you do and be able to track and justify amending it. Again, this one, I don't really run into too many instances of this with the medical couriers. But again, it's one to be aware of, especially if there's a unique relationship that you have with your clients. And then accounting of disclosures. So if you are going to be disclosing PHI to somebody else, including your subcontractors, you want to make sure that you can account for that at any given time when asked for it. From the security side, this is a little more straightforward. One, you've got to be doing an annual risk analysis of your IT systems and the security controls. Access management. Who can access your systems? Is it appropriate? If it's not necessary and appropriate, take that access rights away from somebody. What are your security incident procedures? Again, HIPAA provides the framework for those procedures, so you can align those fairly closely with HIPAA. And as well as the contingency planning and backups. You must have your contingency plans. You must have backups in place, especially if you're using electronic data, as well as workstation security. If you have an office, you have a dispatch office, what are your workstation security measures? Do you have secure passwords? Do you have an auto lockout after 15 minutes of non-use or less? Those kind of things. And again, we have checklists. If you want those, just ask Ken, and I'll be happy to forward those on to you for each of these. Media movement and destruction. This is one where we do see it with couriers frequently. If you are moving medical records or any kind of patient media around, how are you doing that? How are you securing those moving in between stops? I remember Ken talking at one of the conferences, I think it was the first conference 2 years ago. He shared the story of watching a medical courier leave specimens outside in the heat while they went into the building and was doing the sweep of a medical building of others, and it's out there unattended for people to take. Same thing can happen with media. In fact, I saw this most recently as I was going through a professional office building located next to a hospital. I watch a courier. He's going in. He's dropping off. He looks through. He grabs the one set of films he needs, and he drops the rest outside, walks in with the one, and just leaves them there in the hallway. Then he comes back out and picks them up. So we want to understand how you're moving them, how you secure them during transit, and then if you are responsible for any destruction, which, again, most couriers are not, although I'm not saying all, are you destroying media for your clients or your copies of PHI in a way that is consistent with the requirements of HIPAA? Encryption. How is data encrypted if you are transferring this between you and your clients? Are you receiving it? Are you receiving it encrypted? And that's a two-way street because, again, if the lab is sending electronic data, they need to be encrypting it on their end as well. You're going to be decrypting it on your side. So we want to make sure that you understand what the requirements there are and if applicable, proper encryption is in place. You also want to have your audit controls and monitoring, which basically means are you testing within your organization? and are you developing your remediation plans? And again, that goes back to that risk analysis. If you're doing that once a year at a minimum, then you're doing your testing. Obviously, if you find an area that's a high-risk area, you should test that more frequently than once a year. And if you find gaps or you find incidents with it, how are you remediating it? And this frequently you can do with your IT vendor. Whoever's providing you IT support, they can certainly come in and do all that network testing for you, let you know where the gaps are, and then it's up to you to remediate that. And they can usually guide you through that. And then lastly, our integrity controls. And that speaks directly to how do you know that the data you have is correct and the data that you're putting out is correct. So, and as well as non-loss specimens. So you can consider that your QA, if you would. And then on the breach side, there are very specific requirements for any business associate under the new breach notification rule that was put out with the omnibus rule in 2013. And that is that you're going to be running a risk assessment of each and every breach that occurs. You're going to have to, obviously, if the breach occurs on your side as a business associate, you need to make notice to the individuals. There may be notification requirements to the media if it's a large enough breach. You'll have to notify the Secretary of Health and Human Services office, as well as notification to a BA and to other BAs that you may partner with, as well as to the covered entity. And then law enforcement delay. Is there a requirement to report this to law enforcement or not? And then obviously your burden of proof controls when you do your risk assessment, especially if you're answering, no, I don't have to do any of this, then you have to be able to document and show why you don't believe you have to. I would suggest that you contact a firm and your lawyer if there's a breach, because firms such as mine and your lawyers will be able to walk you through what these risk assessment breaches are. So you definitely want to make sure that you're working through that and that you plan now for if this ever happens, what are we going to do, because you don't want to be scrambling at the last minute. Next, let's talk about regulatory injuries, and this is where I usually get a collective groan from whomever I'm talking to. The Federal Trade Commission is starting to flex its muscle, and it believes that it has authority to regulate the healthcare industry, both the covered entities and their business associates, particularly as it relates to data security and privacy issues. Now, the Federal Trade Commission has been around forever. They are the default regulator when it comes to consumers and to data security, and has been for the longest time. Up until recently, though, they've stayed out of healthcare because, again, Health and Human Services has primary regulatory authority over the healthcare industry. Well, last year, the FTC filed enforcement actions against LabMD. LabMD is a fully HIPAA-covered entity with requirements to comply with all the provisions of HIPAA. There was a data breach. Consumers did complain about the breach, but instead of complaining to Health and Human Services, they went to the FTC. The FTC took that as their in they've been looking for. They swooped in, they filed an enforcement action that is now being litigated in federal court because LabMD is pushing back, going, we don't believe that the FTC has a right to regulate us. We're regulated by Health and Human Services, not the FTC. This is going through, and there are two key issues that we're going to be watching this year, and that is, one, can the FTC engage in an enforcement action independent of specific authority, because they have no authority in Health and Human Services. They're relying on their general statutory enforcement authority. And two, can the FTC act in cases where they don't have primary authority? Here, Health and Human Services does. And typically when we see a regulator getting involved in an industry they don't have primary authority in, it's on a referral basis. Health and Human Services frequently refers issues out to other agencies when they detect there's a problem that falls outside the scope of their enforcement authority. They'll refer over to the Department of Justice. They never have, but they could refer over to the Federal Trade Commission. They've done it to other agencies as well. We've had pharmaceutical companies. We've even had hospitals who had engaged in illegal dumping of and disposal of chemicals and prescriptions that led to referrals to the EPA. But in this case, we actually have the FTC stepping in without a referral from Health and Human Services. So we're going to be watching this year because I think we are going to see decisions and answers on both of those as LabMD goes through the federal courts process this year, and we do expect rulings before the end of the year. So it will be interesting to see what happens, but the FTC has come out in their filings in the federal court challenge by LabMD that they intend to step in. They see there are some gaps to the security rule and the privacy rule, and they intend to step in and enforce those and regulate healthcare. So it'll be interesting to see if we have another federal regulator come stepping in to the mix, because that will certainly ratchet up and change how compliance is handled. And they've said they want to look at both covered entities and business associates. So again, we'll watch that over the year, and as things unfold and we get more clarity around that, we'll certainly put a briefing out to the community so that you can be aware of what's going on. Before I get into the fundamental elements of an effective public compliance program, there's one thing I want to talk about, and that is the fact that Health and Human Services is going to be grappling with this year, and they're struggling to get their hands around what does enforcement of business associates look like. Understand when HIPAA was written, they took a very broad stroke, and they did it within an industry that Health and Human Services had great knowledge of and a depth of expertise in. They understood healthcare, and so when this was written, they guided Congress in writing the HIPAA statutes, and it worked. But when they chose to bring in the business associates, when you look at the omnibus rule, it's like taking a very broad paintbrush and just swiping across. Another way of looking at it is it's a textbook approach. Okay, here's how it's going to apply, and it's going to apply to all business associates. Well, guess what? No two business associates are alike. And when we look at the spectrum of this, such a broad range of operations, everything from medical couriers to IT companies to lawyers to firms like mine to CPAs to debt collectors. So you can't come in and audit business associates the same way, irregardless of what kind of business they're in. Health and Human Services has acknowledged that, yeah, we know we probably need different protocols for auditing as well as for determining if enforcement actions have to occur based on the type of business we're dealing with a business associate. Well, as you can imagine, nothing at the federal level moves fast, so it's going to take them a considerable amount of time this year and actually next several years to come up with protocols. They try to get their hands around just how vast the business associate world is and how diverse that world is. So the good news is I don't see that they're going to be coming after medical couriers on any broad stroke anytime soon with audits. Again, if there are complaints, if there are breaches, as those pop up, I think we're going to see them coming in and wanting to look at it, but more from a complaint remediation, possible enforcement standpoint, or from a we've had a breach, we need to understand what enforcement actions need to occur as a result of that breach. So I think they're going to be focused and they're going to be complaint and breach driven as opposed to the broad anybody is fair game for an audit. So that should hopefully give you some room to breathe easy that, okay, I don't think OCR is going to be knocking on my door anytime soon. I don't think medical couriers are going to be targeted in 2016. If I had to bet, we need the guidance and listen to the guidance that I've heard thus far. It's really going to be IT companies and some in the financial sector, so medical billing, medical debt collection. Those are the areas where we're going to see early audit involvement and early inclusion in their HIPAA audit program. I think medical couriers will come down the line. We know Health and Human Services isn't all that fond of labs right now. They think laboratories are high-risk operations, but that's more on a billing and a fraud, waste, and abuse side with Medicare, not on their operations side with couriers. So even though you may see your clients getting under a lot of scrutiny, and I think there will be a lot of scrutiny of labs in the next 18 to 24 months, fortunately, I think it's going to be on the billing side of that, particularly on the Medicare side and on the medical necessity of the tests that they conduct and perform. So I don't think that should give you any concern that you're going to be next if you're seeing your clients get under greater scrutiny. I don't think it's going to apply to you as well. Now, with that said, we usually ask at this point in the presentation, well, how do we end up putting together a compliance program? Well, there are 7 fundamental elements that ought to exist in your medical carrier compliance program. And we know there are 7 because that's what the Health and Human Services Secretary has said that they believe need to exist in any business associate or covered entity compliance program. And those are the implementation of written policies, procedures, and standards of conduct. If I was in your shoes and had to pick where do I get started, I would start with the HIPAA 55 mandated policies and procedures, because we know that under any HIPAA audit, that's what they're going to look for. So I would start my work there. Designating a compliance officer and a compliance committee. Look, most carrier operations are small. You can either outsource your compliance officer, or you can just designate somebody in your senior leadership team to go ahead and fill that role as well. Your compliance committee should be your senior leadership team, and you're looking at compliance issues as necessary, and at least on a quarterly basis, you're meeting to discuss, compliance factors within your business. Conducting effective education and training. Are you training your staff? And obviously, in this realm, the question is, are they getting appropriate HIPAA training? An annual, and certainly Ken and his team provide fantastic training resources. So, make good use of those, because that will make sure that you're doing the effective training and education to your staff. His programs meet those requirements, and then you want to keep good records of that for all of your staff. You also want to make sure there's effective lines of communication. You want to know, and your staff needs to know, including your contractors, to know how do they raise concerns, how do they raise issues, and then what happens when those are raised. How do you handle those? So make sure that you're thinking about that and working towards ensuring that you've got good lines of communication. Conducting internal monitoring and auditing. This goes back to your risk assessment and ongoing testing. So if during the risk assessment you identify an area that you need to spend more time focusing on and thinking about, then you want to test that area as well. If it's a high-risk area for your business, you want to be testing it more frequently than once a year. And then keeping track of both the test and any remediation that you might do to fix any gaps that you find. You also want to enforce your standards of conduct through well-publicized disciplinary guidelines. Let your staff and your contractors know what the ramifications are. If you breach HIPAA, if you don't follow our policies and procedures, these are the consequences that will happen, up to and including termination or termination of your subcontractor relationship with us. And then you want to be able to document and evidence that you can respond promptly to detected offenses and undertaking corrective action. And that goes back to documenting your remediation and when you solve a problem. If you have a complaint, you have a possible breach, you're also responding to those in a timely manner, and not only responding to it, but what corrective action are you taking, which will cause you to do some root cause analysis and say, why did this occur? How can we prevent that in the future? And now let's go ahead and implement what we need to make sure that we're not going to let that happen again in the future. And with that said, at this point, I want to open it up for open mic and any questions you guys might have. Ken? Ken?
Sorry, Ken.
We have any questions coming in?
I'm good.
All right. I'm so sorry. Can you hear me?
Yeah.
Yeah, Ken.
All right. So I do have some questions, but I thought I would let everybody else, ask them first. So I'm going to ask one, and maybe that'll spur some ideas. It looks like no one's jumping to the mic here. Yeah, everybody's unmuted, Linda. That's fine. So there was so much that stood out to me here. One of the things I'm really surprised about is that the FTC inReach. But my question, I'm going to back up on the issues of breach versus exposure. I guess for a courier company, now I own a small courier company, and that becomes one of the biggest things that we often wrestle with. I've done some on-site audits for courier companies on other issues and seen some abuses of it. But I think, I guess my question is, when does an exposure become a breach? If someone leaves charts and files in a public area, but then somebody else comes along and finds it and returns it to the facility, and they work for the facility, let's say, for example, and nothing seems to have been compromised, did they just avoid a breach, or does it still need to be reported because something was left unattended?
In that given scenario, when you run through the risk assessment, because you are going to have to run through it and document how you assess the risk to it, if the person who found them was an employee of the facility, returns it to the facility,
Yeah.
And everything is intact, everything is accounted for, and the employee who found it attests to the fact that, hey, I didn't take anything out of here, I didn't make photocopies for my own personal use, I'm simply returning it because I found it, then no, that's an exposure, that's not a breach.
Okay.
A breach is going to occur anytime a third party gets their hands on that for illegitimate reasons.
Excellent.
And or is given it by accident through negligence on the covered entity or the business associate's part. Now, in this case, they never really gave it to a third party. They gave it back to the facility because it was a facility employee who had found it. Now, let's say I'm visiting the facility that day. I end up getting it. I look through those records and I determine, oh, wow, this needs to go back to this facility, and I take that back to the facility. I've viewed that. I am a third party. There is no relationship between me and the facility. So at that point, it is a breach. The risk assessment is going to walk you through whether or not it's a reportable breach and what kind of reporting is triggered by it. Obviously, you're not going to end up reporting this to the media. There isn't going to be a law enforcement report on this one. And I dare say there will probably not even be a report to Health and Human Services unless it's over the threshold number of records that were included in it, because if I brought it right back to you. But again, it's going to hinge on who found it. If I'm not the employee and I got it, then I am a disinterested third party and I should not have access to it. So that then makes it a breach.
I have another question.
Sure.
In a breach situation, let's say an independent contractor goes out and they're delivering meds to somebody, and they see information on the paperwork that goes with the meds, and they use that to steal someone's identity or harm them reputationally. In a breach situation, who pays, especially if you're using independent contractor? Who pays?
Well, that's a good question. And that's going to depend on a couple of different things. One, it's going to depend on what the indemnification agreements exist between the independent contractor and the business associate, as well as the business associate and the covered entity. In a case like this, obviously, if an attorney gets a hold of it, they're going to want to sue everybody upstream because everybody is liable, including the covered entity. If there is indemnification, then most likely the covered entity is going to get out of it. It's probably going to end up going back down to the offending party, being the independent contractor, through a restitution order, through the criminal prosecution process. However, it does not necessarily mean there won't be civil liability attaching, most notably to the courier, less likely to the covered entity at that point, although it could, because the omnibus rule says everybody's now on the hook together for that one. But that's going to go right back to the business associate agreements and those indemnification clauses that are in there.
Okay. Anybody else? Questions? Don't be shy.
I think I put them all to sleep.
Come on. I mean, I've got another question, but I don't want to hog this this time. So you, in that last answer, you did say that the courier companies could be on the hook as well.
Absolutely.
Okay.
And more apt to be on the hook than the medical practice.
Okay. So I think I had an outdated chart that listed the different types of violations. What are the minimum and maximum penalties that can be assessed? I mean, the old chart that I had went from $100 to $1.5 million. And I mean, is there a cap? Is there a cap on, let's say one of our drivers goes out and commits identity theft on a bunch of patients. I mean, is there a cap on what the liability would be, or can they go outside those guidelines?
No, there are caps, but it is on a per incident basis, and where it gets expensive is on the definition of what constitutes a per incident. You know, you and I would logically think that a per incident means if the guy steals 500 records, that's one incident. He stole it in one time. He just got 500 records. No, there are 500 incidents of theft there. So you can take that and multiply it by 500 and see how those fines get going. Right now, the High-Tech Act certainly saw an upcharging of those fines, and the table gets pretty extensive. I will tell you It now averages between 250,000 and up to, again, the 1.5 million cap on that. But again, it goes per incident. So what I'd be happy to do is give you the latest and greatest chart, Ken,
Yes,
and we
yes.
can put that with the slides so everybody can kind of see what those penalties break out as.
Excellent. Amir has a question.
Yes, Amir.
And he typed it out, so let me read it. He says, what if an IC driver was told by a pharmacy to leave the package or the meds at the door of if the patient is not home and that med is compromised? Who is at fault? And that's a great question, because we were asked to do that by a pharmacy several times because the patient's not home. So great question, Amir.
It is. If you get that instruction in writing from the pharmacy, and if that instruction also makes reference to the patient providing the authorization to leave that at the door, then you're most likely going to be protected. And I say most likely because, again, this is going to come down to a state court issue. It's going to depend on state privacy laws at some point if it goes to a litigation standpoint. If we're looking at it from an enforcement standpoint, obviously if you're acting on the directions of a pharmacy, one, I would certainly get it in writing. You don't want to take that instruction orally. But if you have that in writing, that should get you off of the hook for it from an enforcement standpoint. From a civil liability standpoint, I'd really want to make sure that the patient is authorizing you to leave those medications at the door. If you don't feel comfortable about that, I would not follow through on that request.
What if you don't get the authorization by the patient in writing? Because this is the scenario.
Sure.
I go to the pharmacy, they give me the meds, they say go to John Doe's house. I go to John Doe's house, John Doe's not there. I call the pharmacy, I'm standing on the doorstep, and they say it's okay to leave. So now I've got the okay of the pharmacy, but the patient was gone, and maybe they've got something in their system that says okay to leave, in the computer system, but we don't have a verbal or written agreement from the patient.
The way I would probably handle that is just ask the pharmacy when you're on the phone with them, do you have patient permission to leave this at the door?
That's
Get
good.
them to acknowledge it, because you can always go back and look for that later, but you want that acknowledgement. And what I would have that pharmacy do is send an email or somehow send a written confirmation over to your dispatch saying, hey, we did authorize that this be left at patient Doe's door. And obviously, you're in a fluid situation. You're out in the field. They can't email you necessarily right there that you're going to see it. Take that verbal. Just make sure that you get that email confirmation either by your dispatch or by somebody in the management back at the office for that.
That's excellent to know. Now, at the summit last year, you mentioned something about okay, so the fines aren't necessarily automatic. I think you mentioned something about the fact that if there's a HIPAA breach, then you're given a period of time to fix it, to remediate it, and you fix it, you report, and there's a chance that you might not be fined. Does that depend on the egregious nature of the breach or your compliance?
It's a twofold factor that they're going to look at. They're going to look at how egregious was the breach. If it's a large breach, if it was an Anthem Healthcare size, if it was a Sony size breach, you should expect there's going to be fines. There's no way you're not getting some kind of a fine.
Mm-hmm.
Obviously, for everybody who's on this call today, you're not going to have a breach the size of either Anthem Healthcare or Sony. So in that case, you may be able to skirt the actual monetary fine. What they're going to look at, though, is not only the size of the breach, but they're also going to look at your responsiveness. And if you remember back to the 7 tips for an effective compliance program, one is, are you handling this in a timely fashion? If you wait to the very last day and then only then start addressing it, well, you're doing that because you're hoping not to get fined. They don't view that you're taking this seriously. You respond right away. You're taking the necessary action. And you're doing that because you're remediating it. You're making the necessary acknowledgments back to the covered entity above you. You're taking whatever remedial actions internally you need to take. They're going to look at that and say, okay, you're acting reasonably. You're doing what you need to do. And the chances are you may very well escape fines. And I've seen that happen where they will get out of a fine because they're taking it, because they've taken reasonable actions and they've done so in a very timely manner and they've taken it seriously. It's the companies who kind of stub their nose at the regulators to go, we don't think this is so serious. We'll do the minimum to get by on slowest possible course of trajectory, those are the ones where they come in and they just have no sympathy for them, and they're not willing to work with them. So again, it really comes down to how seriously are you taking this and how quickly are you responding to it. Obviously, the more quickly and the more serious you take it, the better chances you are to have a favorable outcome with the regulators.
That answered one of my other questions about, once you receive notice that you're being audited, is it too late to avoid fines? But I guess what you're saying is it depends on how we react and respond. At that point, once you've given notice, the audit is about to happen, so you'll need to get a lot of things in place. If you don't have a program in place and you start putting that in place after the notice, I mean, is it kind of after the fact and still too late, or are they going to look at that and say, okay, they're really trying?
Part of that's going to come down to unfortunately, the realities is depending on what kind of an audit team you get. If you get some hard-nosed auditor, particularly your lead or senior auditor, who's just cranky and out to get the world, then you're going to have a much rougher audit than somebody who's a little more reasonable. What I would say is anything you can do before the auditors show up to put your compliance plan in place, you should do. And you should be open to constructive dialogue with them, with the auditors, and they will have that dialogue with you, if not that while they're on site, certainly afterwards in their preliminary readout of their findings. Here are our findings, and here's our guidance. If you work with them and you collaborate with them and take that guidance and you can show remediation plans, particularly if you're sitting in front of the auditor and they're zeroing in on something and you're seeing that the same gap that they're seeing, before they leave, you guys need to be working after hours and saying, okay, how do we remediate this? Would this work? And then you can go back to the auditors and say, hey, look, we believe there may be a gap here, and we think we can close that gap by doing this, this, and this. What do you think of that? Would that meet the requirements? I'm going to tell you that's going to go a long way for you, instead of just waiting until they come and they tell you what to do. So the more proactive and the more engaged you can be through the process and the more you can do beforehand, even if it's after you get the audit notice, the better off you'll be than not having anything in place. But I want to emphasize, don't wait until you get the audit notice, because I guarantee you there's more to do than you'll have time to get done. Again, just putting stuff on paper doesn't work. You have to be able to implement it. You have to be able to test it. And from the auditor's perspective, business associates were fully covered and fully required to comply with HIPAA back in September of 2013. We're now end of February 2015. They're going to be wondering what you were doing for the last year and a half.
Good point. Good point. Questions? Anybody else? Questions? It's been some great information. I actually, I got distracted towards the end, but I took a lot of notes, and I realized that just having a program in place and having your drivers sign something that says, I know I'm responsible, isn't enough. And so I think a lot of companies that are using ICs are doing just that. They're having them sign a single sheet of paper saying they understand their responsibilities, but then the company isn't self-auditing. They're not putting procedures in place. They're not monitoring the job duties of the drivers, making sure they're all staying compliant. I mean, there's a lot of things that I think that are not happening by courier companies and leaving them really exposed. So,
And Ken, one final suggestion. Take somebody from your management team and have them periodically, unannounced, ride with an IC for a day and watch what they're doing. It's the best way, especially if they don't know it's coming until you show up and say, "Hi, I'm riding with you today." Yep. It'll give you an opportunity to spend the day with your IC, and then that can go a long way to building rapport between you and your IC. But at the same time, it gives you that opportunity to independently verify that they're doing what they need to do.
Great. I have a question from Richard. If your vehicle is stolen, again, he typed it. If your vehicle is stolen with specimens on board, what would be your first moves?
Notify the police department, get that police report going. Hopefully you have GPS on your vehicle so that you can track that. The second thing you want to do is notify the labs where you've done your pickups that it's been stolen, that you're notified police and you're working to secure it. But step one, get the police involved right away to find that vehicle.
Is that good, Richard? Did I answer it for you? So you're going to notify the police and get that going, and then notify your client as to what's going on. I think they're going to be the ones that will be able to identify the patients that were affected based on the number of stops that you did, because that's already in their system. Most cases,
Exactly.
Most cases, those requisitions have been printed out, and the paperwork has been sent into their IT systems already, knowing that it's coming. So, any other questions? Go ahead.
And the key there is to identify the specimens that are sensitive, particularly temperature sensitive, time sensitive, because they can at least get in contact with those patients and get them back in for a new sample if they need to, especially if it's an urgent test.
Great question, Richard. Thank you. Anybody else? Well, I just want to also mention that Keith's going to be at the summit this year, again, speaking on HIPAA issues, and so we're going to have an opportunity to have more direct access to him and ask more questions. There's a lot to keep track of, and as courier companies, I think that doing the preventative work to make sure we're fully aware of what's going on with our drivers and make sure that our program in place is compliant and keep up with that on a regular basis is going to really save us in the end, because, you know, the old saying, an ounce of prevention is worth a pound of cure. Yeah, it may take staff hours to make sure that we're all on the same page and make sure that we're monitoring our drivers, but the fines could be exponential and in some cases could take a company down. So I guess if there's no other questions, we can certainly close the meeting for today. Keith, I want to thank you so much. The information that you've given, my head is swimming, and I've heard you speak a couple of times already, so you've gave us some great information, and I want to thank you again for taking time out of your busy day to speak to our group.
Oh, well, thank you, Ken, and thank you, everyone, for your time today. I appreciate it.
All right, thank you so much. All right, everybody, have a great weekend coming up. If you have any other questions, you can always contact me directly at ken.arnold@integritydelivers, or Keith. His email address is on the screen right now, so you can reach out to him. So is his phone number. So I am going to try and figure out a way to make this recording available. Some people had asked about the slides. Stephanie had to leave almost right away before you started, Keith. So we'll try and figure out a way to make that available. If you want that, reach out to me and I'll work on that. This is a new process, so we want to make sure we figured out how to make it happen. But again, I want to thank all of you, and we're going to go ahead and close the meeting. So,
thank you.
All right, have a great day, everybody. Thanks.
Thank you, Ken and Keith.
You're very welcome.
Very informative.
Yeah, it was. Thank you, Angie. Have a great day.
Thank you. Appreciate
All right.
it. Bye-bye.
You got it. Bye. All right, here we go.